Welcome to the People's Law School. I'm Cynthia Sanderson, Family Court Judge in McCracken County, and today we're going to talk about domestic relations, or family law as most people call it. Thank you for joining us. Along with me is John Reed and Brian Katz, two attorneys in Paducah that concentrate in the area of family law. John, would you like to start out by discussing custody, perhaps, a pretty large, broad subject, any aspect of that?
Sure, I'll get us started on that. A lot of the people we see, obviously, as you're aware, do have children that are under 18. And if you have children under 18, then one of the issues you're going to have to decide is who's going to have custody and who's going to have, or what kind of custody are we going to have. Why don't I talk a second about just joint custody in general, and then I'll let Brian talk some about some shared custody arrangements. Most people, I think you would agree, to go through your court nowadays, unless there's some really strong reason not to do it, you award joint custody, meaning that both parents have equal custody to their children. And a lot of people have a misconception about that, I think, because a lot of people think that that means that, well, one of us is going to be the decision maker. And we do call people primary, which I think is a misnomer. We call people primary residential custodians. And so those people who get that, and that's where the children normally live, sometimes think, well, I get to make all the decisions. And of course, you're well aware, and Mr. Katz is, and lawyers are, that the Supreme Court of Kentucky has said now if you have joint custody, you have absolutely equal decision-making power. But still, normally, you're going to make one of the parents the residential parent where the children normally live. And I think I've been doing this a long time now. The history shows that it's really worked out well. People have to cooperate a little better if they have joint custody. And in the old days, when you made one parent the sole custodian, you didn't do this. In the old days where we had a family court, and the judges made one parent the sole custodian, the other parent just visited, I think my experience was that empowered one of the parents to feel superior and to really use that to sometimes do what was not in the best interest of the children.
Okay.
Now we have another arrangement that you do not force on people, but some people like to agree to, and that's a shared arrangement. I'll let Brian talk about that.
All right.
I'll talk about that in a minute, but maybe let me ask if John, you ever have the situation come up where the non-primary custodial parent comes to you and they don't feel like their ex-spouse is honoring that commitment, and they're not being involved in decisions, they're not being asked for their opinion, or maybe if they give their opinion's ignored. Do you have that decision come up, and what sort of advice do you give to people if they feel like there's not teeth, if you will, to the title of a joint custodian?
What I would try to find out from that person is whether they really have a real concern or whether they're concerned about maybe petty issues. Because my theory is when the children are with one of the parents, that parent's going to decide what they're going to eat, when they're going to go to bed, what they're going to do that day. And those are day-to-day decisions, and whoever has physical possession of the children, I think, should decide that. Now, if a person comes to me and says, no, I'm not talking about that, I'm talking about where the child goes to school, or we're fussing about what doctor the child's going to go see, I heard that guy's no good, and my wife wants to take the children to that guy, you know, I think those are legitimate issues, and in that case, what I'll usually do, if the other person has a lawyer, is fire off a letter and, you know, say, hey, go back and read the Supreme Court case, and I can't remember the name of it now, but that said that joint custody means just exactly that. Everybody shares in the decision making.
Right.
So I think you have to look at that as, you know, is their problem a real problem or just a perceived problem?
I think what happens a lot of times is the expense of talking to lawyers and the cost of litigation, that only those problems that really people can't live with are the ones that get brought to our attention, and sort of over time people learn to sort of find some happy medium of what they can or can't live with. So I agree, I see that.
Let's ask her a question before you talk about shared. Do you have many people come back to court and say, I'm not getting any say-so with the children?
I get people that come back to court that say that. To say I get a lot, I can't actually characterize it as many. It's usually major issues, education issues where they've taken the child out of school without approval of the other party. I think that's a violation of the joint custody arrangement if they don't discuss it and come to a mutual arrangement about it. Unfortunately, we do have a right to move as a joint custodian and take our children with us if that happens. And obviously, you're going to change the child's school, so whatever you're going to talk about, it still gets back down to where would a child go most conveniently to school. So the bottom line is, while you get to talk about those issues, the residential caretaker is probably going to be the person that's going to dictate it by virtue of where the person lives. That gets into a whole new area of the moving, and we'll get to that in a moment. But let's go back to Brian.
Sure.
And ask, what is this, what's the word?
Shared.
Shared custody. We don't use it a lot, but
I think I see shared custody come up in certain situations where parents are particularly able to talk with one another and work out almost a 50-50 sort of time-splitting arrangement. From my perspective, it's very similar to joint custody in that parents are still going to talk about decisions involving the kids, but that term to me describes more of an even time-splitting arrangement where a child or children would spend either 1 week with one parent and another week with another parent, or Monday, Wednesday, Friday, Tuesday, Thursday, and Saturday, and then you split Sundays or something like that. So that's the arrangement that I see, but I've, as you mentioned, John, I haven't seen the court impose that unless the parties wanted that and agreed to that.
okay. To the extent that you've seen it by agreement, does it work pretty well?
I have not seen a lot of complaints in those situations. I mean, those are cases that are agreed upon, at least with respect to visitation going in, which is a good sign that perhaps they're going to be able to agree upon things down the road as well.
Mm-hmm.
I have not seen big problems from shared custody arrangements that don't tend to work. Whether they change down the road and they don't come back to speak with a lawyer, I don't know, but I haven't seen big problems with those arrangements. Have you, John?
I have seen some problems, and I think it's, I've been in your court before when some educators have testified before about they have some misgivings about that because they feel like, particularly with young children, if people have a complicated schedule, such as some of these 2-2-3, Monday and Tuesday at one parent, Wednesday and Thursday at the next parent, then back to the first parent Friday, Saturday, and Sunday, and then flip-flop that the next week. And I know I was in your court one day, and an educator here in town testified that she had seen some second and third graders who were living under that arrangement, and there was always a lot of concern by the child as to who's picking me up, what am I doing today, who do I go with, am I going to get my homework back from wherever it was yesterday. And I had a case one time that where the people had voluntarily done this, but as the child grew older, the child developed some issues with bedwetting, eating disorder, and they took the child to a psychologist that basically said, this child needs a home. He needs a bed, he needs a pillow. It's okay to visit Dad or Mom, but he needs a place to call home. And in that case, my client was the man, and he voluntarily gave up his shared arrangement because he saw it was not, his child was not adjusting to it very well. So I think it takes two parents that are really willing to work together, and then I think it takes a child who's somewhat adaptable because, as we all know, children are all different. Even in the same family, they're different.
Certainly.
My experience with you is that you do not normally impose that on people.
I don't impose it on people usually. I think maybe once or twice I have done that. From the court's perspective, of course, we have to look at what's in the best interest of the child, unless it's a modification, and then that standard would change to a higher standard, like serious endangerment, under certain circumstances. But assuming it's just an original issue with parties divorcing and trying to decide who gets custody, trying to find out what's best for the child when you're listening to two parents argue over where a child should live, and one parent is saying the child is best here, no, the child is best there. I usually, when people cannot agree, it's hard for me to envision down the road that they can switch off a child on a every other day basis, every other week basis, where this is really going to be a good thing. And also, the younger the child is, it's like John has just mentioned, the younger the child is, where they are and where they're going to go on a particular day is a very important thing. They may not know what day it is, they may not know what time of the day it is, but they want to know where they're going to go at the end of the day. And unless you're older and can have a good concept of time, that can get very confusing for a child, and which lends itself to confusion and lack of stability. And critical element for all children is stability. Stability in parenting, stability in home life, stability in knowing that when you come home you're going to have a parent there that treats you the way you expect to be treated, the way you're used to be treating. So I think from my perspective, in trying to view it in what's best for the child and looking at it through the child's eyes, I like to think that that a child's going to have the least bit of confusion. And I know sometimes that that the result is against one party or the other that doesn't necessarily, that wants that arrangement. But I haven't gotten to the point yet where I feel like in every case that it would work out. So, you want to talk about a split custody arrangement where children are actually separated, the siblings are separated?
I see that so rarely that I would just suggest to people that you have to have a really strong reason to do that. I did have a case one time where there were 3 children, and literally one of the children was just such a problem that literally, and you didn't have that case, you were able to get out of that for some reason. Judge Hines had the case, but he interviewed the children, and 2 of the siblings basically said, please let our brother go live with Daddy because he's mean to us. And we just don't want him around. And the child was having a lot of problems in school with the same kind of issues with antisocial behavior. And the judge did split those children and let the son go live with his dad, who he thought might be a stronger disciplinarian.
Yeah.
John, we better hope that there aren't any young girls out there listening that want to get rid of their brothers. You just suggested how they might do that.
Well, it did work. There was a boy and a girl that wanted this brother gone in that case, an older sister and a younger brother, and they both wanted the child gone. But I don't see that. I think that's just so unusual. I don't think people should even consider that, splitting the children. I've never seen you do it.
I don't split the children unless the parties agree to it, because I think siblings need each other. I think, again, that's the stability issue. They come home, they've got a sibling at home, and they need that consistency and stability as much as possible, particularly at a time when one of the parents is no longer there.
The only time I've seen that arrangement is when there were one parent had adopted the other's child and or vice versa. Mm-hmm. And when they split, they took their birth child and didn't have their birth child be in the primary custody of their ex-spouse.
Right.
I guess I've seen it in a moving situation too. If you have a child who's about to graduate from high school and the parents divorce and there's some younger siblings and mom or dad's going to move out of state, they may split then to let that older child stay where he or she already is. And so, I mean, there are some situations, I guess, where it's understandable, but I don't think people should get it in their minds that they're likely to come in and win one child and lose the other, because I think you win them all or you don't win them at all, basically.
Right. Now, there's one other definition or one other type of custody, and that's sole custody. We've just briefly discussed that. Brian, you want to give a little more detail as to what that really means?
Sure. As John mentioned, originally custody is about decision making, and joint custody means both parties should have input, and sole custody therefore means that only one party is vested with the power to make decisions, and they're not, at least under a legal obligation, to consult with their spouse about those important issues that John talked about. People frequently come into my office and say they want sole custody, and my typical response is, unless your spouse is a bad dude, is basically the way I describe it. Or the other situation where You may be able to win sole custody if it's really, really a situation where parties can't talk, can't converse, can't agree about anything. Then it's almost a situation where if the court imposes joint custody, they're almost setting them up for failure. But you know, in the normal run-of-the-mill case, as John said, Your Honor favors joint custody, and I think most lawyers recognize that and agree to that. And typically, parents, the parent that would not have custody is not likely to agree to that. It makes them feel like they're not going to be a part of the child's life.
I just don't. I mean, I try to warn everybody now. I agree with Brian completely. Unless there is some really powerful reason why your spouse should not have joint custody, you don't go there. You're wasting your time. You're wasting your money. You're going to create a lot of ill will with your spouse, because I tell everybody, you award joint custody, and I suspect you award it in 99.9% of the cases. You know, and even in the situation Brian gave, where the parties can't get along at all, that almost, when you award sole custody, then you guarantee that's going to have to continue to happen, and you almost reward the person who's really, because normally it's the person who's going to get custody that's being so difficult about it.
Right.
And I've seen that in the old days, where I felt like before old days, 20 years ago, basically the standard was sole custody, and normally it was the mom. And I saw in those days sometimes that you empowered a person who was going to use her children as pawns against the dad, which was obviously wrong.
Right.
And I think joint custody takes some of that away and reins in people a little bit to force them to try to cooperate.
Right. I think more often than not, a circumstance where I would award sole custody has to do more with the inability to make good decisions, such as substance or alcohol abuse, or the distance perhaps between the parties and the unavailability of the other person to be jointly involved with that decision making, rendering it inconvenient or impossible to join in talking about the decisions. So we try certainly not to get parents empowered more one against than the other, because as John pointed out, giving them that power is not a good thing. You want them to be equal parents as much as possible, acknowledging that a child has to live somewhere. Let's talk about child support, because a lot of this kind of plays into all of this. I know the answer. I know everybody here knows the answer, but does it matter whether you get any of these types of custodies in determining the child support amount? Does it matter what you call it?
That's one of the first questions people ask me. If I have joint custody, do I have to pay child support? Or if I give him joint custody, does he have to pay child support? Do you get that question a lot from people?
Certainly, yes.
And the answer is that joint custody doesn't change the child support obligation at all, that it's a mathematical calculation. You take his income and her income, add them together, look at the chart, look at how many children they have, do a percentage, and that's what you're going to pay. And that was the same thing was true with sole custody too.
There are some issues that come up, though, as we talked about, Judge, as far as having different type of arrangements, be it a shared custody arrangement. Frequently, people want to know, and I get asked, if I'm going to have the child with me X amount of time and I'm supporting the child, do I still have to pay the full guideline child support amount? John suggested that it's a formulaic calculation where you crunch numbers and it is what it is. But invariably, if parents have more visitation, sometimes they want to know, do I have to pay the full guideline amount? And I've seen your Honor say yes, and I've seen your Honor say no. I guess it depends upon the circumstances.
Yes, unfortunately, the General Assembly hasn't spoken to that issue directly. They've kind of avoided it over the last few sessions. There's some case law that does tend to support discretion about that. In other words, I can say yes sometimes and I can say no sometimes. But the bottom line is that we don't technically acknowledge a formula for dividing out child support based upon a time sharing. We can do that, but it's not a requirement. And that's another area where we get back to, well, should we share custody? Or is this really about getting a reduction in child support? Does that parent, whether it's the male or the female, does that parent seek a shared custody arrangement to get a reduced child support amount, or do they truly want to be responsible for the upbringing? I think for the most part, people that want custody truly want custody, and I for the most part, I believe that if they're going to bear the burden of providing a home and meals and clothing and all the necessities of children, some part greater than what a non-custodian would be considered, then they should get some benefit. How much? That's a different story. That's where the discretion lies.
And it's a difficult situation to advise clients on, I find, because by definition what you're saying is you have to measure it against some baseline, and I don't know where that baseline is. I think we sort of assume that the baseline is that you would get what we call standard visitation, and if you have a lot more time than you get in the standard schedule, that's the measuring stick to determine you don't have to pay. I mean, you don't get a reduction if you have standard visitation, but if you have a lot more visitation than standard visitation, maybe you do.
Mm-hmm.
I was going to make sort of a joke about it, that when my clients bring that issue to you, of course, they're very sincere, and they have every reason to get a reduction. When Brian's bring it, they're just really doing it for to try to get a reduction in their child support.
Right.
But I mean, I think I agree. I philosophically have a little problem with it because so many expenses of raising a child are sort of set. If you have 3 children, you probably can't have a 1-bedroom apartment. If you have 4 children, you may even have to have a larger vehicle to drive. And so maybe because I've been on the side of trying to keep it from being reduced, philosophically I sort of go with the position that unless you really do have a shared arrangement where you're splitting the children 50-50, and that's a whole different issue to me in child support. But if a guy's getting an extra overnight every other week or so, I mean, if I have a male client who I think can't win residential custody, and I can get him some extra time, then it sort of really irks me if he wants to then say, well, hey, I don't want to have to pay my child support, because my gosh, which is it you really want? You want the extra time, or you just want a reduction in your child support? So I encourage people, and I encourage my female clients to try to give some extra time, and I try to get extra time from my male clients, and I really try to leave the child support out of it, because I think that creates a whole nother issue, and I don't see you really modifying it, let's say, unless you get up to the 40 or 50% range.
Yeah. It's kind of a catch-22, and correct me if I'm wrong about this, but let's say the father has custody and the mom has visitation rights. It's a joint custody arrangement where they're hopefully making joint decisions about those major issues. And Dad's being very generous to Mom in the sense of allowing more overnight visitation, more during the week visitation than what's in the standard schedule. And he's doing this because he's a nice guy and because he thinks the children will benefit by this arrangement, not only with him being the parent, but also the children having this other parent as well. And then a year or two after this arrangement's been going along and Mom's been playing this part-time mom and moving in a little bit more and more, she comes in and she says, hey, I've had the children, and she's been documenting every day that the children have spent 6 hours with her. She's got 6 hours down on her calendar. And I've had the children 35.6% of the time. She's coming into court and saying this. So I want a reduction in my child support that I'm paying him. So Dad's been nice in allowing it, and Mom's been taking advantage of it, which you would expect her to, but now she wants repayment for all the, it's one of those no good deed goes unpunished. And what do you think? What do you think I ought to do?
I think you should say no. You should tell her how lucky she is that the guy she had her children with would let her have extra time with them. I really do. I just don't see that's a reason to modify the child support.
I see the other situation as well, where you have a client who is getting more time, and they raise the issue that you said sometimes irks you, John. They talk about a reduction, and I've certainly advised clients that as soon as you raise that issue, you're going to get that time cut off. and you better just be thankful for what you have.
Exactly,
Mhm.
Yeah.
exactly. And so you don't want to really discourage the time-sharing arrangement. You really don't, because I think that children do benefit by spending time with both parents, assuming they're both fit and suitable parents, and most parents are.
And
At
odds
least-
are the child support payor thinks that he or she is paying too much, and the recipient thinks they're not getting enough. And if the recipient thinks that they're going to lose money because they've tried to be sharing, if you will, then they're likely to cut back. But I guess I hear it from both ends, John. I'd be interested to hear what your opinion is about whether more people think they're paying too much, or you hear more people that receive child support think it's inadequate.
Well, I mean, I think we can all, I think we can all agree on this, and that is, I'm going to be a good politician and I'll answer the question. Because what I'm going to say is, the child support that a person has to pay under the chart is a pretty high amount for most people, and it's after-tax dollars. So when they pay $1, they have to make $1.10 or 15 or 20. So I feel that person's pain that has to pay child support. On the other side, whoever's receiving the child support, if you really start adding up what it costs to raise a child, and if you have children that are active and you're paying $3 a gallon to drive them to soccer practice and softball practice and baseball practice, the truth of the matter is, for most folks, there's not enough money to go around. And so it's an amount that probably doesn't cover the expenses it should, and yet it still hurts for the person that has to pay it, because it takes a big chunk of their take-home pay.
Right. And when you say take-home pay, child support's not actually calculated on take-home pay.
No.
It's calculated on gross pay, or before taxes, or before deductions for retirement plans, or any kind of 401k or that
Right,
sort of
right.
thing.
Those tend to be the issues that get litigated in child support cases, is what is somebody's gross pay. A lot of people get a paycheck and it's fairly easy to determine, but other people that are self-employed or maybe don't get all their money in a paycheck where it's on a W-2, those are the issues that tend to get litigated. We typically are able to work out the other cases because it's fairly clear what people make, but as you point out, it's based upon gross pay, not net pay.
But now I have a question to ask you, because this always comes up. Does overtime pay count for figuring child support? Of course, I know the answer, but why don't you tell the audience, because that's a question that I get a lot.
It does. It's in the statute. Any income that you receive. Now, of course, everybody that comes to court that ever had any overtime doesn't have any overtime by the time they come to court. And I say that tongue-in-cheek, of course, but that is usually, and John, you've had clients that lost all their overtime.
I'm laughing right now.
And Brian, I know you have too. And it's really hard to determine what the future tells. Nobody here's psychic, as far I've been studying it, but nobody really is psychic, and so we don't know what the future tells. And it's, you have to look at history.
You've seen a lot of letters from those bosses, though, that say, Johnny's not going to get any overtime from this point on. We're finally cutting it out. And of course, he's been working the same plant for 10 years, and he's had overtime every year he's worked there. But now all of a sudden, going through the divorce, it's no longer going to be available.
Yeah.
You've seen those, I know.
Right. But overtime technically, as well as bonuses, commissions, any sorts of income except for maybe assistance like SSI, food stamps, those things are not considered as income. To give the viewing audience just a little idea about how child support runs for varying incomes, let's take a minimum wage employer. That's $893 a month gross before taxes. Their child support, if the custodial parent had no income, and that is sometimes the case when a child is below the age of 3 and they're unemployed, that child support would be $180 a month. I don't know how much net income is on $893, but that's a substantial sum or a substantial percentage out of that person's income. As the income goes up, the percentage goes down that is used for child support. For instance, if your income is $10,000 a month, and the other side has no no income. The non-custodial or the custodial parent has no income. Child support is $1,000. That's 1/10 of the gross income versus what, about 60, about 60%?
The first example is about 20%.
20%.
Yeah.
Right, I think so.
Yeah.
And Judge, you might just tell the viewing audience, if they're just keeping track of that, how many kids you were assuming they had?
I was looking at one
One
child.
child.
If you have $893 worth of income and have 2 children, you pay $261. That's the other thing. The more children you have, the less per child you get. I guess statutorily, or the folks who came up with this system said that it's cheaper to raise 3 children than it is to raise 1 child on a per child basis. And that would make sense. You still have to heat the whole house. You still have to have a certain accommodation. And so while you may need an extra bedroom, you don't have to have an extra car for that extra child. So
Right.
the other thing that the statute gives consideration to is health insurance costs. Do you want to describe that?
Well, basically, the court tries to have one of the parties be required to provide health insurance, and the party that provides it it gets factored into the formula, where essentially what happens is the party that pays child support is going to pay their proportion of that premium payment. So if a party pays $100 to cover the child or children, and the parties have equal income, and therefore their pro rata incomes are 50% of the combined total is contributed by one parent and 50% by the other, then that party that does not pay the insurance would have to pay an additional $50 to cover their portion of the premium. Did I describe that right?
Yeah, that's right. Now let's talk about property issues for a while in a divorce. John, do you want to start this out?
Sure.
Talking about the different issues of property.
Sure. We start with the proposition, particularly if people have been married a long while. And unfortunately, the older I get, the older clients I get, so I see people who have been married 20 and 30 years. And as you're aware, the assumption by the law is that all property you own is marital property, and the statute says it will be equitably divided, which I tell people all the time in practical terms means you're going to divide all the marital property equally between the parties. And I will tell you, I have clients that have a lot of problems with that, and it's always the person who's made the most money. It can be a male or a female. Certainly had both situations, and they feel like somehow that's wrong. If they made most of the money and my marriage is broken down, why should I have to split my property equally with my spouse? But that's the assumption we start with. And then we have what's called non-marital property. Why don't you tell us what non-marital property is, Brian?
All right. Non-marital property would be property that you brought into the marriage, and that may be tangible items like furniture that you inherited or something. Non-marital property could be property that was given to you during the marriage by gift, or something that you inherited, or if you could trace that you had a sum of non-marital money before the marriage that you bought something with during the marriage, you could try, and so long as you're subject to being able to prove that, that would be non-marital property as well. So as John was saying, in the division of property, the parties get to keep their non-marital property, and then you essentially divide the marital property evenly. A lot of times it's pretty easy to tell what's marital and what's non-marital, but in a lot of cases assets are both marital and non-marital. An asset can have both a marital component to it and a non-marital component to it. John, do you want to describe that?
Well, sure. The example I would give would be if you owned a car when you got married, and you say you haven't been married too long, because if you've been married too long, it'll be impossible to trace. But you owned a car when you got married, and a year into the marriage, you traded it off. You were allowed $10,000 on a $20,000 car. if you got divorced the day you did that, then I think you would agree with me that $10,000 of the new car, or half the new car, is non-marital of the person that owned the original car, and the other half is marital. So to buy out the other party, you'd have to buy half of the marital, which would be, I'm talking numbers now, which maybe I shouldn't, you'd have to pay basically $5,000 to buy them out. And that would be a typical example of mixed property. I want to go back a second about the equal division, because I get this question, actually I get it more now than I used to, about when you're dealing with marital property only, not talking about non-marital property, but marital property only, and let's assume that no one's been a squanderer, nobody's been a drug addict and squandered a bunch of money, or gone to the riverboat and blown too much money. How do you normally divide marital property?
I usually split it right down the middle.
Now what if one of them's been a bad boy or a bad girl?
Split it down the middle. Unfortunately, that's not, under the law, a reason to divide property differently. Marital fault is not a reason. Marital contribution is, though. In other words, if it can clearly be shown that one party contributed a greater amount to the acquisition, that is a consideration. But what does that mean exactly? It's not real clear, but certainly you can sit home as a housewife, clean the dishes, put the food on the table, wash the clothing. The husband can do the traditional role of going out to work, while the wife does the old traditional role of staying home and being a mother and housekeeper. And that is marital contribution. We recognize the value of a housemaker and a parent in the role in the marriage, and it's valued as much as the wage earner under the law. Would you agree with that?
Yeah, I don't know if you get these, Brian. I have a lot of people now that go on the internet and they're reading the law, and they come in and they've read the statute, and they read that contribution thing, and they're just convinced that what that means is, if I made $50,000 and my spouse made $10,000, then I made 5/6 of all the money. I want 5/6 of all the property. And I just have to almost argue with some of my clients that they don't want to pay me to take that argument to you, because you're not going to buy that.
Well, do you think I should buy that?
No, because that's not what contribution is. Never intended to be a monetary contribution. If it was in the situation you just described, then if Dad was the work outside the home and Mom was work inside the home and get no salary, Dad would get everything when they divorce.
Right, and that's not the intent of the statute. I think when we talk about contribution, it really does go to more towards squandering the funds, misusing the funds, maybe applying funds toward things that didn't benefit the marriage, giving away money, maybe having an extramarital relationship where you put money into. Again, that kind of crosses over to fault. Fault's not an issue, but you can bring those issues up if it shows that they squandered money because of it.
Right.
I think practicing before you, I think lawyers pretty much realize that the cases are few and far between that you're going to do anything other than split things 50-50, which makes it easier to settle cases. If you were a judge that was interested in hearing those arguments in every case, it would make it really, quite honestly, difficult to settle cases, because one party or the other is always going to think they should get more than the other party.
Right.
So if nothing else, having that sort of starting point assumption that everybody's going to get 50-50 helps lawyers evaluate their cases and settle cases. I had a case before Your Honor recently where you didn't do a 50-50 division, and I think the reason in that case was you thought that the parties had lived apart quite a bit of time, and property that was acquired during the time between when they got married and when they got divorced was considered marital property by Your Honor, but the fact that they weren't actually living together as husband and wife made you feel like that was a factor that should lend towards one party getting a little more than the other.
Yeah, and I think that's contemplated under the statute. How can you have a contribution if you're not living as husband and wife?
Right. It says marital contribution, so it assumes, I think, that the parties are living together as a husband and wife, at least in the same household.
Right. Answer me on this. What piece of property or item of property do folks have the hardest time splitting under a marital division?
Well, I know which hurt the worst.
Yes.
The pensions.
Pensions,
Pensions
yes.
hurt. Whoever has the bigger pension feels really put upon that they have to split that with their spouse. We're lucky in a lot of cases nowadays that both parties have pensions, so we're just splitting half of the difference is
Right.
all we're splitting. But, oh, absolutely, it hurts. I mean, I know when I have to tell somebody that, sometimes we have clients come in, Brian, I know you've experienced this. Every question they ask, it's an answer they want to hear, because that's just the kind of they're asking the questions that I can tell them things that are favorable to them. And other clients come in, and everything they ask, I give them an answer that they're going to hate, and I'm thinking, this person's going to hate me when this is over. But I think we have to tell people the truth, because otherwise they'll be misled, and they will be really bitter when it's over
Certainly.
if your lawyer misleads you as to what you're really entitled to. But it hurts people, particularly if they've been working somewhere 30 years and have a pension of 30 years and a big 401k, and they have to split that, and add into that then if the other spouse has been unfaithful.
Yes.
And then they really feel like, oh my gosh, what's going on? They ran around on me, and now they're getting half of my pension.
But again,
It's a no fault.
It's a no fault state, so that means what it means. Fault does not enter into the division of property. When does fault enter?
I tell clients I think it can be relevant in two issues if it invariably comes into custody issues. I don't know that it's contemplated to come into custody issues, but it's always something that you can talk about if instead of spending time with the family or the children, they're doing something they shouldn't be doing. So it invariably can come into evidence in that situation. Then I think the other time in the statute that it's contemplated is it can be used to defend against a claim for maintenance. In other words, the party that has committed marital fault can be penalized, if you will, for if they're seeking maintenance. That can be used against them.
Judge, do you have any idea why did Kentucky choose to call alimony maintenance? Because that's the most confusing thing to so many of my clients. Everybody knows what alimony is. Everybody
Sure.
watches TV. Do you know why they
No.
chose to call it maintenance?
Well, they changed it.
Does it sound better? Is that why you think?
I guess. It used to
It wouldn't
be
be as offensive.
Yes, it used to be alimony, but I think when it became more gender neutral, they changed it to maintenance, to maintain the spouse. And I think alimony is often considered a money that in the past was given to mothers or women to support them. Of course, we have palimony in other states. We don't recognize it in Kentucky, and so we all know what that is in other states. But they've changed the wording to maintenance, which is a spousal support or alimony.
I have a question to ask you, because I agree with Brian, although I think we have to acknowledge if you get the statute on the internet, you will never find the word fault in our statute. Except with non before it.
Mm-hmm.
And yet the Supreme Court, or the old Court of Appeals, about 2 years after the law was changed, I think in about 74 or 76, came out with this case that said if someone is asking for maintenance or alimony and they've been messing around, then you reduce, or you can bring that up to get a reduction. But nobody, it's not like child support, there's no formula. I want to ask you, for future reference for Brian and me, let's say we'll say it's the man's asking for maintenance. The wife has a great salary. The man's never made much money. In fact, he's even been the one that stayed home with the kids most of the time. But he's been having affair after affair after affair for the last 10 years, and the wife finally said, I'm tired of supporting you, and I'm tired of putting up with your mess. I'm kicking you out. And he files a motion for maintenance. How do you judge what to do with that?
Well, first of all, fault doesn't come into determining whether he's entitled to maintenance, but only whether there should be a reduction in the amount of maintenance. I think that's how the statute reads, or the law reads on that, if I'm correct. So the first question is, are they entitled to maintenance? And that's a completely different issue it's a different issue than how much maintenance. The question of entitlement boils down to, do they have the resources or income to support themselves, whether they're independent resources from their own income after the divorce, division of property pursuant to a divorce decree, or inheritance that they may be receiving in the past or the future. So all of those resources are considered in determining the need, whether the person is entitled to it, whether they need support or can they make it on their own. Now, once the entitlement issue is resolved in favor of the person asking for maintenance, the next issue is how much. Then you've got a laundry list of factors to consider there, and I think that's where the fault issue comes in. And if you say, well, he or she is has been a good spouse, no fault, then you'd set it at a certain amount. However, if you find fault, you reduce it.
Do you in fact do that in your?
Actually, I do.
Yeah,
and the reason
do you have a percentage a range that you use, or is it just sort of every case is like a snowflake? They're all different.
I think that's pretty much how it has to be. Unfortunately, it kind of comes from the gut, and depending upon how terrible or how it's not good law. That's all I can tell you.
Well, Judge, you're to be commended for answering these questions. If you were nominated for the Supreme Court, you could say, I can't answer that because that question may come before me.
Hey, I have no political aspirations beyond today.
Do you remember the case in Marshall County where the lady claimed that she had multiple personality and it was the bad Jane that was out messing around?
Yes, I do.
And the good Judy was actually a good homemaker and a good wife, and she tried to use that for an excuse. Because I think the judge over there, I know he did, he reduced her maintenance and she appealed that, and I think it was the Court of Appeals that said that one won't fly. You have to have a better excuse for messing around than you have multiple personality, and your bad side did it, not your good side.
Yeah.
Have you had that argument in front of you yet?
Never. I hope I don't, but I thought it was quite interesting.
It's a novel argument, I will say that.
If you can find the clinical support for it, absolutely.
But unlike child support, like you've mentioned, there is no formula. There is a computer program that floats around the state that was created by someone outside the state that I think some judges utilize. I occasionally look at it to see if I'm on track with, I usually look at it after the fact, but the considerations are basically need. How much, and ability to pay. How much does a person need to support themselves, and what's the ability of the payor to pay? So when you start juggling those two things with utilizing the facts you've heard in the case, it's usually it's not an easy answer that comes up, because there's never enough money in these cases, but somewhere you'll find a medium in there.
I tell people that come in, I think it's the grayest area in the law, and I also find it's the hardest issue to settle, because lawyers we don't feel comfortable telling people what's a fair amount of maintenance, because it is just, it's really difficult to try to figure, since they made child support easy. It used to be the same way. Nobody knew what it should be either. And they did a chart, and I know some people tried to come up with some formulas, X amount of money times X number of years times this or that or whatever, but for me it's a really hard issue to get somebody to feel comfortable with, and it's a very hard issue, I think, to settle. I think you see, I would suspect in most significant maintenance cases, they end up being tried in front of you, is what I suspect.
Right. And that's because, again, there's a lot of factors to take into consideration. How long was the marriage? In addition to the amount, you have to come up with a duration that the maintenance will be paid over for future years. There can be a short-term maintenance, and that may be just during the action itself, or it can go on beyond that for a number of years, or it can be a lifetime award. And it's interesting how much different the cases are depending upon whether it's short-term or lifetime, because as we all know, for the most part, lifetime awards can be revisited at any time depending upon changes in either party's circumstance. Whereas whereas short-term awards cannot be. So
There's some great language in an old case too that it's a Paducah case. In fact, it went to the Supreme Court of Kentucky, and it's the life. What would be okay for the lifestyle of a scullery maid would not be okay for the lifestyle of a duchess, and I think that makes a valid point that people need to understand, and that is, you're going to try to award maintenance to help a person try to stay in the position where they were financially. That's at least theoretically what we're trying to do. In theory, we know that if you take a finite amount of money, you can't live separate and apart and each have the same lifestyle. But I think people have to understand that if your spouse makes several $100,000 and you've been married 20 years, you're looking at a figure that's much greater than if you've been married 25 years and your spouse makes $50,000. There's simply not, he doesn't or she doesn't have enough that you're going to get a whole lot. And of course, I think health issues are huge. To me, they are, at least. If the only lifetime awards I see in your court are where I see people that have a health issue, that they're disabled, they cannot work, and therefore they got to have help forever.
yes, those are the sad ones, for
And
sure.
they're pitiful. They are really sad for both sides, quite frankly. Here's a couple divorcing, and yet one's going to support the other one to some degree for the rest of their life. And the person that's disabled, though, is never going to get enough money to really live very well.
Right,
Really
right.
sad.
Right. We like to talk about lifestyles and trying to allow the person to live in the lifestyle to which he or she has become accustomed to. But in reality, that never works unless the folks make a huge amount of money. And there's so few of cases like that it's a rarity that we see that happening. You know, as a practical matter, you cannot split homes and live separately as cheaply as you could live together. And so it's impossible to take the same amount of income and divide it and make it both parties live at the same lifestyle. But the statute asks you to do that, and that never works.
What do you do if you have a case of, say, I hate using these genders, and I've changed a bunch of them, but this one I'm going to use, the traditional gender. The lady's been a stay-at-home mom for 15 years. The son or daughter's now 14 years old. They do have a degree. They're healthy, but they haven't worked in 14 or 15 years. And Dad has a decent job. He works at one of the plants. He has good benefits. He makes a decent salary. He's certainly not wealthy, but they've lived a comfortable lifestyle. What are you going to do for her? Let me ask you this. Do you expect that woman to go back to work, or does she get to maintain her lifestyle if she gets to stay at home and be a stay-at-home mom?
Oh, I think she's ultimately going to have to get a job, and that's pretty much what I say. Go get a job. Preferably, give her an opportunity to develop a skill or a trade, or get a quick education, not a doctorate or anything like that, but a job or an education or a skill that would put her in a job market that could meet some reasonable needs. But no, I expect people to work. We're all out there working this day and age, so unless you're physically unable to, I think it's important that we all do our jobs. Let's talk about something that we usually don't talk about, and that is, in this community there's been a growth of methamphetamine users that seems to be pervasive, more pervasive with mothers than other drugs have been in the past. Are you seeing mothers, young, middle-aged mothers, come into the courts who have an addiction to methamphetamines losing their children?
Oh, absolutely, and it's heartbreaking. And Brian and I were talking about this before we started today about just a few years ago, maybe 2 years ago, I never saw any of that in my practice. And now I have grandmothers who are coming in to try to get custody of their grandchildren because mama's doing meth, and who knows where daddy is. He could be anywhere, maybe in the penitentiary, he may be doing meth too. And it's heartbreaking. And I see it in all socioeconomic, the whole range. I see everything from people on food stamps to people who have enough money that you would think, why in the world would they be messing with meth? But they are, and it's just, it's heartbreaking.
And of course the results of getting addicted to meth, and I understand the addiction happens quite quickly, is, as I see it in the courtroom, is that it renders them unable to take care of their children. They put the addiction first. They don't want to eat, so their refrigerator's not child friendly. It doesn't have food and milk in it. The house is a complete mess. They can't even walk through it because they're not thinking along those lines.
Those children are absent from school a lot, aren't they?
Their children, I get that. I learn about meth cases in truancy court a lot because the parents aren't getting the children out of bed, or maybe the parents have partied all night and the child can't get a good night's sleep to work and school the next day.
Well, there have been cases, have there not, Judge, where there were health risks just from the fumes and or the, I know the meth is, or at least in the making of meth, there's certainly things that can be ignited involved, and I know there's been some of those cases where houses are burning down and that sort of thing. But I think you make an interesting point, and I was just trying to ponder why. I mean, a number of years ago, crack came on the scene, and that was supposed to be highly addictive and inexpensive, and yet, I guess as you point out, mothers that perhaps could resist the temptation to become hooked on crack maybe are not as resistant to be able to stay off the meth, and maybe it's just that much more addictive. I don't really know, but
I don't have an answer. I've heard some answers as to why it's so addictive. I don't think it's appropriate for this program for me to go into those reasons, but it apparently is extremely addictive. But the result is what's so sad that we see in the courtroom, that parents are losing their children, and children are, if there's not a relative placement, of course they end up in foster care. But I certainly, I think all of us want to encourage families with family members that have issues about that to certainly seek out to help those children and seek protection for those children, because typically those children that are in the homes of parents who are using meth are not being adequately provided for. It just doesn't happen.
what is the appropriate action in your mind for someone who knows or suspects that children's parents are involved in using or selling meth? I mean, what would you recommend that they do?
Well, there's a number of ways to go about it. You could file an action in my court for custody, either on an emergency basis or in a non-emergency basis. And either way, if you can prove that the child is being affected or that the parent is utilizing the meth, then chances are you would be successful if you could show the effects on the child. There's no good effects for meth with a child. We're just about to wrap up this segment of the People's Law School. Is there any final statements anyone wants to make?
Don't get involved in the meth.
Don't get involved with the meth.
That's for sure. Try to make your marriage work if you can.
Absolutely.
You won't have these problems then.
The grass is not always greener on the other side.
Evidently not.
No.
The best divorces are hard and difficult.
Exactly.
Right.
For the parties, for the divorcing spouses.
Exactly. I think and the victim of most divorces with children involved are the children. Thank you for joining us.
Thank you.
Judge.
And thank the audience for joining us on People's Law School.